Good morning. This is Vice Vice Chairman Pearman. We're waiting for two board members. We also have some additional materials just received. So before we get to the agenda, which includes elections and then the Baker matter 6223-1, we'll recess till approximately 9:45. Thank you.
You want me to call the tour? Okay. All right, we are back on the record. We have all 5 of our board members here. Today on the agenda is the swearing in of our reappointed members for engineering, Mr. Mohan Balagopalan, and our attorney member, Mr. Robert Pierman. And then we will have the election of the chair and vice chair, and then we will take the case for Baker. So I'll turn it over to Madam Clerk, Faye Thomas.
Thank you. Mr. Balagopalan and Mr. Pierman were reappointed by the governing board on June 7th for another 3-year term ending June 30th, 2027. So if you would both please stand, raise your right hand and repeat after me for the oath. I state your name.
Robert Fairman.
During such times as I hold the above office, do solemnly swear or affirm that I will support and defend the Constitution of the United States
that I'll support and defend the Constitution of the United States
and the Constitution of the State of California
and the Constitution of the State of California
against all enemies, foreign and domestic,
against all enemies, foreign and domestic,
that I will bear true faith and allegiance
that I'll bear true faith and allegiance
to the Constitution of the United States and the Constitution of the State of California,
to the Constitution of the United States and the Constitution of the State of California,
that I take this obligation freely
that I take this obligation freely
without any mental reservation or purpose of evasion,
without any mental reservation or purpose of evasion,
and that I will well and faithfully discharge
and I will well and faithfully discharge
the duties upon which I am about to enter.
the duties upon which I'm about to enter.
Thank you. Okay, so this morning, we're conducting the elections for chair and vice chair for a 1-year term. We'll start off with nominations for chair. Are there any nominations?
I'll nominate Mr. Ali for chair.
Are there
Second.
any further nominations?
Yeah, I second.
Okay.
Are there any further
Are there any further nominations for chair?
No, there's no. Okay, I'm going to nominate Miss Cynthia Verdugo for chair.
Do we have a second on that?
I'll second.
Okay, thank you. Are there any further nominations for chair? Hearing no further. Okay, sorry. Hearing no further nominations, I will close the floor for nominations. The following members have been nominated for chair. First, we have Mr. Ali, nominated by Mr. Pierman, seconded by Mr. Ali. How do you vote? By roll call, how do you vote? Board Member Abraham?
Are we going to have the candidates at least make any sort of statement or?
I'm sorry, you wanted to make a statement?
You don't? I mean, no, I don't know. I'm just
no,
curious.
We'll just vote on the first person and then we'll vote on the second. So Board Member Abraham, how do you vote for Mr. Ali as the chair?
I'll vote aye.
You vote aye? Board Member Balagopalan?
I would no.
Board Member Pierman?
Aye.
Board Member Cynthia Verdugo Peralta?
No.
And Board Member Ali?
Aye.
Well, the motion passes for Mr. Ali as the chair with a 3-2 vote.
I'd like to move Mr. Pearman as vice chair.
I'll second that.
Uh,
And so we have Board Member Ali nominating Board Member Pearman as vice chair and seconded by Board Member Balokapalan. So by roll call vote, how do you vote? Board Member Abraham,
Aye.
Board Member Ali,
Aye.
Board Member Balokapalan,
Aye.
Board Member Verdugo Peralta,
Aye.
and Board Member Pearman.
Aye.
The motion passes 5-0 with Mr. Pearman as the vice chair. Thank you.
All right. Thank you, members of the board, for your support.
Can I make a statement?
Go right ahead.
I just wanna
Absolutely.
Thank our hardworking chair for the last 3 years. I think she only missed one meeting where the doctor kept her under lock and key. And really, she's been to every one that I can recall. And so I really appreciate that time, and maybe she can relax a little bit and not have to rush here at times, or can do some remote from her bedroom or something like that next time. But she's been a great servant, and we appreciate that and look forward to a continued role.
Thank you, Mr. Pearman. It's been my honor and privilege to have served as chair. It's not an easy task, but I believe that this is a good board that we have, and it's my honor to continue on as the chair, as the member. So congratulations to Mr. Ali.
Thank you. And I also want to congratulate Ms. Verdugo Peralta for her tenure as chair. We've tackled some very tough decisions. And I believe we've done it with a measure of class and elegance, but we've been very forceful and very intentional with respect to advocating and advancing the mission of this organization, as well as in securing and safeguarding the quality of air for those who are least among us, which is why we're here serving in these capacities and serving in this role. And so I want to thank Mr. Pearman for serving as vice chair for the past 3 years, and look forward to his steadfast leadership, in addition to welcoming the attorney as well as the engineer member back. It's always an honor to be reappointed by a group of folks who see the value for which you bring to an organization. I thank Dr. Abraham for his steadfast support and leadership. All right, so we're gonna get to a solution today. That's the objective, is to get to a solution and get to it expeditiously. So what we have before us for the public is a case involving the South Coast Air Quality Management District versus Baker Commodities. Before we move any further, we're going to take audience comments pursuant to the California Government Code sections as listed. We're going to take audience comments one time at the beginning of the meeting pursuant to our agenda. We will not take it throughout. We'll take testimony, but we will not take public testimony or public comment as listed on the agenda throughout the meeting. Madam Clerk, are there any individuals who've sought recognition to provide comments?
Mr. Chair, there are no members on Zoom with their hands raised. And I have received no speaker cards for any members of the public who are in person at this time.
Thank you very kindly. If any individuals do seek recognition, provide testimony relative to the matter, we'll hear that. But again, we're moving forward with respect to public comment pursuant to the sections as listed. We're going to move forward and hear from the district side, the district representative, the petitioner.
Hi, this is Daphne Seifert, Executive Officer. I wasn't sure if the board wanted to take testimony. I know that Baker had some exhibits. We don't believe the diagram pertaining to the pit drainage is relevant at the time, given our agreement on the abatement order conditions. Also have a closing argument, but I wanted to defer to Baker's counsel in case they want to speak on whether or not there would be testimony before closing.
Okay, so you want to defer at this point?
In terms of if they want to speak on the issue of whether or not they're going to have a witness.
Would you, for the record, please state your name, representing Baker.
Yes, Isabella Neal representing Baker. I'm joined by George Jiganis remotely. We have our witness from the earlier hearing available, should the board have any questions for him. We don't plan on presenting witness testimony at this time.
Thank you.
Would you like me to close first, or would you like Baker's counsel to
No, you
close?
can go ahead and close first.
Well, thank you, hearing board, for providing a draft order in advance. It allowed us to discuss it with Baker and come to agreement on some items. The key disagreements remaining are: one, whether to allow material to remain overnight, and two, how frequently washdowns should occur. South Coast AQMD's proposed order centers the community's concerns of potential odors. This is why our proposed order is more stringent than Baker's. I will go over the rationale for our significant revisions, including ones no longer in dispute between the parties, if it differs significantly from what the hearing boards had in its draft order. So if you have our documents in front of you, you could look at the comparison of Baker's document with AQMD's proposed revisions. That might be the easiest way to follow along. Go ahead.
I'm sorry, before continue, Chair, can we mark this?
Yes. And this exhibit will be. So this exhibit will be number 43 for the petitioner. Okay. So this is 43 for the petitioner.
Which one? There are three of them.
Okay, so there are three documents for the record. There are three documents from the district. How do you like to have these marked?
How about 43 is the clean version, AQMD proposed findings and decision. 44 could be comparison of hearing board document with South Coast AQMD proposed edits. And 45 would be comparison of Baker's document with AQMD's proposed revisions.
Okay.
So looking at condition 4, which of the attachment A,
Which one, 44?
let's look at 40. If you have 44 and 45 open next to each other, I think that'll be easiest. So looking at condition 4 in attachment A, we had deleted the first sentence in the hearing board's draft order because it no longer applies. The permit applications have already been deemed complete, and Baker is in agreement with the deletion. We added, Baker shall not modify the pit in the raw materials receiving area until Baker receives a permit to construct for such modification. And Baker is in agreement with this addition. We added a part that said for capital improvements described in section 8 below to clarify which permits are being referred to. And we have not had a chance to discuss this provision with Baker.
And Baker's has no objection to that addition for capital improvements described in section 8 below.
Thank you, Mr. Kikanis. So moving on to condition number 8. We added a sentence providing a deadline for when Baker must provide additional information requested to process the applications. Baker still has not provided comments or suggested revisions to draft permits provided on May 6th and May 16th. Thus, we believe a deadline is necessary and helpful. Baker has agreed to the addition of this deadline for additional information. I do have a question for the hearing board. The proposed order by the hearing board states that either party may go to the hearing board if we do not agree to the extension of deadline for capital improvements. So my question is, what is the default after 120 days? May Baker continue collections? Must Baker cease collections? The order does not say.
Which condition are you referring to?
In condition 8, the hearing board had put, if the enclosures cannot be completed within those 120 days and Baker and the district are unable to reach agreement regarding an extension to time, either party may submit a request to the hearing board for extension to Baker's time to complete the enclosures or for suspension of collection operations until such enclosures are complete. So, go ahead.
So who had the floor? Mr. Balakaplan, you had the floor?
I think it was.
Or was it Mr.
Pearman.
Pearman?
Well-
Did you want to opine?
Yeah, I can comment on.
Go right ahead.
She suggested what, the way I would interpret this and why I drafted was, basically the status quo doesn't change until you come forward. So if you anticipate you won't make the 120, someone needs to come to us quickly and say that we want you to suspend or we want to get more time. So it's kind of like, let them control it. If they're kind of happy with the status quo, they may take their time coming to us and let things go along. But this way they can anticipate and say, looks like it's not going to work. And then depending on how things are going, they can either say, we want you to suspend, we want you to extend time. So I think it's deliberately left open to allow you to just move before us appropriately.
So if neither party comes to the hearing board, would Baker be continuing to collect or would they cease collection during that period of time after 120 days has passed?
If they were already collecting, they would be able to continue that subject to condition permit.
Okay, thank you. It is the district's position that we would prefer that there be a suspension of collection unless Baker comes in for an extension of time. But thank you for clarifying, Mr. Pearman. For condition 9, both parties had made an edit and agreed that it's the term Baker bins, not roll-off bins, that should have its free fall height enclosed, and we made that revision. For condition 11, 11B, parties agreed to the revisions whereby Baker can only use the slab prior to pit modifications, and both parties have agreed to the storage limits. 11C allows Baker to receive materials from 6 to 9 p.m. except in cases of emergency. We added language that only 3 days of emergency every 90 days shall be allowed. This echoes the language in condition 11D, which allows 1 emergency every 90 days. We are even more generous in allowing 3 days every 90 days. Baker disagrees and asks for 9 days of emergency every 90 days. By definition, an emergency is unexpected, and an event happening at a frequency of once every 10 days seems to be a regular operations instead of a true emergency. Thus, we ask that the hearing board use our proposal of 3 days of emergency every 90 days. For 11E, we deleted the provision allowing overnight storage in the permanent total enclosure. We have very serious concerns regarding potential odor if material was allowed to be stored overnight during the summertime and continue to degrade in the enclosure. Baker's previous process was a continuous process, likely ensuring turnover of material. And now Baker wants to be able to store the same material up to 3 days. The district is very concerned with potential odor, and the public is too. Imagine a garage with tons of animal carcasses in the heat of the summer. Imagine the smell. How long would you want the material to sit in the garage before being removed? The district's proposed order gives Baker flexibility by giving additional time to remove material until midnight and 3 emergency days. Our proposal acknowledges operational needs while still minimizing potential odor. Now moving to 12, Romanet 5. Because of our concern with potential odor, we ask for a wash down of the receiving area every other working day. We understand the facility is closed on Sunday, whereas Baker proposes a twice weekly wash down, and we propose 3 times a week, every other day. Baker also added additional language stating that the wash down of the interior of a screw conveyor is not required. We believe this language is unnecessary and confusing, as the screw conveyor is still being permitted and the screw conveyor will not be in use. Further, we have not had any testimony on the specific issue of the wash down of interior of a screw conveyor. Now on to condition 12, Romanet 7. Both the chair and Baker had alluded to the difficulty in tracing odors to the facility. Thus, we revised 12 Romanet 7 to allow remedial measures if there's an NOV related to receiving hard material after odor complaints, not due to odor complaints. That is not because of a nuisance NOV. I believe that Baker, and let me double check, did also agree to this language. So for example, if the district received odor complaints and found the facility had not been abiding by washdown provisions, the district may issue an NOV, and in the next 30 days, the district would be able to ask for more severe remedial measures. We use the phrase first notices or is notified of such odor instead of Baker's term made aware of the odor. We would agree to Baker's phrasing if it means the same thing as our phrasing. They're very similar. We made revisions to specify that Baker would follow its odor response plan. Baker agrees with this revision. At June's hearing, Baker and the board discussed concerns regarding when remedial measures would be taken if the facility was closed. Our proposal provides Baker 4 hours to complete the steps in the odor response plan. Baker disagrees and asks for 8 hours. We believe 4 hours is sufficient time for Baker to contact staff and have them arrive on site and complete its odor response. We respectfully request that the board implement South Coast AQMD's proposed revisions filed yesterday. Baker starting new operations, collections. That has never been done before at this facility. Please listen to the community's odor concerns. Removal of material every day and wash down the receiving area every other day would assist in allaying these concerns. Thank you very much.
Thank you. Now we're going to hear from the respondent. Now, you also provided 3 documents or multiple documents. And so at this point, with respect to the numbering convention for exhibits, you're at HH. How would you like to note these documents?
Yes, so we'd like to have, we have as our first document on top of the pile there, a clean version of Baker's proposal. So we can have that be the next consecutive exhibit, II, and then so on from there. The next document that you see in there is a red line against the hearing board's version against Baker's version. That could be JJ. And then following those 2 exhibits, we have a number of schematics and renderings to assist the hearing board in understanding Baker's proposed system for draining the PTE pit. I would propose that we include all of those documents together as one exhibit. If that won't make things too confusing for the hearing board, then we could have the collection of exhibits be exhibit KK.
Okay, so, yeah, we're aye on, yes, the proposed findings and decisions, doc is aye. Let's go over that one more time. Sorry.
All right, so the second document in that pile will be exhibit KJ. Red line will be JJ. And then we have a number of schematics and renderings those all together can be KK.
I don't have the JJ document. Sorry. This one. That's right. All right, we have the JJ. And then you want all of these schematics, plumbing plan, pit enclosure, in addition to it's 8 additional documents. 8 additional documents plus the plumbing plan R/M pit enclosure will be KK. Okay,
That's
very
correct.
well. Okay, no problem. All right, the floor is yours.
If I may, Chairman, can everybody hear me okay?
Yes, sir.
Okay. Thank you very much. And let me add my congratulations to members Balagopalan and Pierman on their reappointment and on your election as Chairman Ali. And thank you again, as hopefully this is our last hearing, at least for quite some time. Thank you to all members for their attention and considered thoughtfulness on this very important matter. That's much appreciated. And happily, I agree with the district's council that the parties have worked together again, as we have in the past, to narrow the issues. And I believe that the district's council has provided an accurate rundown of the open issues, although of course we would disagree with some of the characterizations. Essentially, there are a few minor issues that have to do with number of emergency days or the timing of odor response measures, and I will discuss Baker's position on those. And I believe that we will successfully come to a resolution on those issues today. There's one key sticking point, and that sticking point addresses 2 issues. The first is the turnover of material, the frequency of turnover of material within the permanent total enclosure. And the second is the frequency of washdown of the pit if the pit is used. And that is, those issues are related because Baker will wash down the pit when the pit is cleared of material, which Baker, as I will describe, can do on a twice weekly basis. And so those 2 issues are related. The one thing I do disagree with, counsel for the district said that it would not be necessary to go through the drainage schematics. It will, because the pit modification, there are essentially 2 stages of the pit modification. The first is the placement of the panels that we discussed at our last hearing and at our first hearing as well. The removal of screws and placement of panels, which the parties have agreed will require a permit to create that construction. If that construction occurs and those panels are placed prior to the permitting of the bigger screw conveyor system and permanent total enclosure extension that would allow Baker to replace the screws in the pit and use the screws and the screw conveyor as ultimately planned. Then there will be a period of time during which we have the panels in the pit with no screws, and we will have that washdown system in place. That's why we have in this order the pit washdown provisions. And so we have created drainage schematics. Baker has invested resources in developing those schematics at the request, I believe, of Madam Chair from our last meeting. And we are happy to walk through those schematics with the boards so that they can understand and appreciate the attention that Baker has paid to this, the investment that Baker has made and is willing to make in making this drainage work, and also, of course, just how it will work. So we've provided those schematics as exhibit JJ, I believe, and Ms. Neal is prepared to walk the board through those if the board would entertain that. And we can do that first, or I can sort of complete my closing and walk us through the remaining open items in the proposed findings and conclusions.
Sir, why don't you complete your closing and then walk us through the items accordingly?
Okay, excellent. So I will walk through the open items in our closing, and I will and then Ms. Neal will be able to provide the details on the schematics of the drainage. So one opening statement for our closing, so to speak. I hope that this board has received the impression, which is accurate, through the course of these 3 hearings, that Baker has taken a very serious and resource-intensive approach to trying to save its business and trying to save the jobs of the employees that it has worked with for many years. We have come to, as we mentioned at the outset, Baker has come to the conclusion that rendering at this facility is no longer viable. And in order to salvage this business and have, remain operating in the way that it, or at the capacity that it has previously, it needs to be able to operate as a collection center or tolling facility. And Baker has made every effort with our involvement and our pressure and our work with the district to make every concession possible to doing this business in the way that the district would like it done. This is not a business that is subject to Rule 415. This is not a business that, if it were a collection center that were just starting elsewhere, would be subject to the types of restrictions that we are agreeing to in this order. Those restrictions we acknowledge are in place because of how we got here. And I believe Baker has demonstrated through its investment of resources, through its commitments to trainings, to capital improvements, to changes in operations that the district has requested, to responsiveness to the hearing board, that it is very serious about odor control, odor reduction, and responsiveness to both the district, its regulator, and to the community that it operates in. And so with that context, I will ask this board, when we walk through these items, to allow Baker a chance, to give Baker the opportunity to show that the operations as planned will not create unacceptable odor, and that the odor control measures Baker has in place will operate to control odors in this community as required. I don't say lightly that Baker's proposal is the best that it can do in running this business. To provide a little bit of transparency into our discussions with the company, we have discussed the issue of how often Baker can commit and guarantee essentially that material will turn over within this facility while keeping a viable business. We've discussed that issue at length with the company, and we have provided as much possible concession in our proposal as we can in order to operate the business at this capacity viably. So let us start with some of the details, having provided that preface. I believe Counsel for the district, Ms. Shu, has accurately walked through the agreed revisions, which do capture some additional concessions that Baker has made, including timing for providing information, including the agreements regarding getting district approval for emergency conditions, and most importantly, agreement that before the pit is modified, there will be a permit to construct for modification issued, and that a maximum of 60,000 pounds of hard material will be on the slab. In other words, whether Baker is able to place the panels into the pit, remove the screws and place the panels through the granting of that permit, or whether Baker has to move directly to the screw conveyor system with the PTE extension. Prior to that time, Baker will store a maximum of 60,000 pounds of material using the slab. The next issue where there's some minor disagreement, I believe it's relatively minor, is regarding hard material receipt, the receipt of hard material, the timing of that receipt. The parties agree that 6 a.m. to 9 p.m. shall be the norm. The district has asked for 3 days of emergency allowance, and Baker's asked for 9. The reason that Baker asked for that is not because Baker anticipates using 9 days of emergency in every 90 days. It is because, as I hope the impression has been given to this board, this is a dynamic business and a dynamic operation. There are many moving parts. There are 11 trucks, multiple trucking routes, different days of trucking routes, hopefully a significant number of customers to coordinate and to respond to in picking up their material. And there are all of the dynamics that occur in the real world that can create emergency situations. Other facilities may break down or may need to shut their operations for a period of time. Traffic issues, truck breakdowns, driver emergencies, or other types of problems. Those things can occur. And so we're asking for this board to consider that more than 3 days may be necessary within the 90-day period. And also to consider that Baker will be in communication with the district about any of these issues. And if the district believes that there is some sort of abuse of this provision going on, that's absolutely within the district's authority and ability to call that out. So we will leave on that. We'll leave to the hearing board. If you have any questions, we're more than happy to answer them. But hopefully we've sketched out that disagreement sufficiently. If there are no questions there, then we'll move on to the next provision, 11E, and what would be E and F in our proposal.
Yeah, Mr. Dragonis, just a quick pause for a second. Member of the board, are there any questions of the gentleman, Ms. Verdugo-Peralta?
Thank you. I did have some questions in reference to the 2 issues that you have that are outstanding, that you stated in reference to the turnover of the material, the frequency. What exactly is the main reason that you don't want to agree with the district's proposal on that issue?
There is no way, thank you, Madam Member, for your question. There is no way for Baker to guarantee that it will be able to move material out of the facility within a 24-hour period, although that is absolutely the aim. To remove the material from the facility every night is impossible because material, as we just discussed, will be coming into the facility depending on customer needs, depending on routes and the dynamics of when those routes are completed, up to 9 p.m. And that material will then have to be transferred to trucks that will be able to leave the facility. And depending on how, when those trucks can come in, how quickly those trucks can be loaded, and when those trucks can move out of the facility, there's no way for Baker to be able to guarantee that it can remove material from the covered, completely contained PTE with it by the end of the day, whether it's 10 p.m. or midnight. And that is something we've brought Mr. Andreoli to this hearing so that if there are specific questions or if the hearing board would like a discussion about the specifics of logistics that prevent that from occurring, we're happy to have Mr. Andreoli discuss that. But I do think that this hearing board should consider providing some deference to a business that has operated in this capacity or has operated in this general area of business for decades. And it is very earnest in saying that this is as much as it can commit to turning over material twice weekly, and that there really is no further room for increasing that frequency. Now, as I've said, that does not mean that all material will sit at the facility for 3 days. I want to make that very clear. That is not the objective. That's not the intent, and that's not what's going to happen in the normal circumstances. But we can't sit here and tell the hearing board that material can be removed every night or that all material will turn over within 24 hours, because we don't want to end up back here or end up in another disagreement or problem with the district. And we need to be straightforward about what the operational capacity and abilities of the business are.
Any additional comments or questions from members of the board? Mr. Primer?
Just though, so if we can't do it that day, you're asking for 3 days. What's the magic of 3? Why not 2? Why not 48 hours? What's the difference?
So, as I understand it, some of it depends on, or some of it has to do with the timing and frequency of material coming in. Some days are much heavier in terms of the input of material than others. Tuesday, for instance, is a very heavy day of material coming in. Wednesday is a day that's spent largely getting material out of the facility. And therefore, that's the logic of our proposal, which would be that the pit wash down, the pit would clear and the pit would be washed down on Wednesday or Thursday every week once. And then again, that cycle repeats. And again, that would happen on Saturday or Sunday of the same week. So I'd be happy if the hearing board would like Mr. Andreoli to give more detail to that. I'm obviously a lawyer, not a collection center operational person, but my understanding is that different customers in different days, or different customers have material to collect on different days, and therefore the material will accumulate at a non-linear rate, and there will be certain days that will be heavier, and therefore other days that will be largely focused on moving material out of the facility.
So is 48 hours feasible?
So I'm sorry that I have to say the answer is no. We have really pushed on this issue and tried as hard as possible to reduce this time as much as possible. And if I could tell you yes, I would love to say that, but I cannot. And I'd like to along with that answer, just remind the hearing board that this is not a garage. And I take issue with the district's analogy or metaphor about imagining a bunch of rotting meat sitting in a garage. That is not what happens here. Meat comes into this large and permanent and totally enclosed structure. Much of it, if not most of it, is refrigerated when it is collected. So it is cool material that's coming into the facility. The material is turned over on a regular basis, usually more frequently than the 3-day period that we've described. And when it is in the facility, it's in a large, again, facility that's protected from direct heat exposure and direct sunlight. It is not a small, low-ceilinged facility that, you know, might be akin to a garage. And, you know, material that's at the bottom of the pile is not obviously subject to emanating odors. It's only the material that's at the surface. So to some extent, you're not, whether you have 50,000 pounds of material in the pit or 100,000 pounds of material in the pit, it's the material at the surface that is largely, you know, the material that would be susceptible to creating or emanating odors. So there's a lot of differences between what we're talking about here and the idea of somebody's sweltering garage at home.
Are there any additional questions or comments from members of the board? Ms. Verdugo Peralta has the floor.
Thank you, Mr. Chair. The second question that you, or the second issue that you had mentioned was the washing down and the frequency of the washing down. How many man hours does it take to do that? How many people do you have on it, and how long does it take them to complete the task?
So for the first question of how many people, I'd have to ask Mr. Andrioli, and maybe Ms. Neal can do a sidebar with Mr. Andrioli. Again, I apologize for not being in person today. I believe the answer to the second question about how long, I think it's around a 3-hour process is what has been discussed previously, but we should get that the accurate answers to your two questions from Mr. Andrioli.
Thank you.
Mr. Balakapalan.
Yes.
Well,
sir.
I'm sorry, hold on one second, sir. No disrespect. But you want to provide the answer?
Yes, yes,
Yes.
please, and thank you for your patience on that. We estimate that it would take approximately 4 hours to wash down the PTE pit and would take 1 or 2 people.
Okay, based on that answer, then why is it so difficult to just add another day on there? If it's only 4 hours, it's 2 people, that to me
Right.
does not seem very difficult.
And that's correct. But the issue is it's directly tied to whether the pit is vacant. And so if the pit is in use, but as you know, I've probably spent too long discussing previously, it can be turned over. We can guarantee that it can it can be turned over twice weekly. And when it is turned over, it will be washed. So that's the reason for the wash down frequency issue. That's why I said at the outset they're related. They're essentially the same issue.
Thank you.
Mr. Balakapalan, the floor is yours.
Thank you, Mr. Chair. Just, Mr. Jimenez, just to clarify, I'm looking at the Health and Safety Code, section 42450. And it says the district may, after notice and the hearing, issue an order abatement whenever it finds any person constructing or operating any article, without a permit or in violation of a rule. So I just want to clarify, are you constructing something without a permit right now?
No, sir.
Are you operating anything without, are you operating anything? Besides the Tribe Creek's operation?
There's no raw material. No raw material has entered this facility since this order of abatement was first issued.
So is this an preemptive order abatement when you do start processing material?
The idea of this proceeding here is to modify the order on abatement so that it provides an interim period for Baker to do collections while it is constructing the enclosures and the 3 enclosures of the other operations, as well as the PTE extension.
I should have brought this up before. What is there an option for the board to just nullify the order abatement and let permitting do its job of issuing the permits for the new construction? Because there's no rendering. The order when initially issued was for to cease all rendering, subsequently modified to allow wastewater, trapped grease processing and cooking oil, which is not associated with the rendering. Now you've surrendered all the permits for the rendering. I know you've agreed to this stipulated order, but I'm just having, why are we still continuing with this order? If you can clarify, why we need to.
This order provides for operations prior to the issuance of the PTE extension permit and prior to the completion of construction of the 3 enclosures. I think that was the design of what we were trying to do here, was to allow this operation to happen before the enclosures which have nothing to do with the raw material, but before those enclosures were constructed, and then before the PTE extension permitting and construction was completed. I believe that we're well within the hearing board's authority to issue this order. I think I presume that the hearing board members agree, given that the draft order was issued, and I think the parties are in agreement that we should move forward this way. I would suggest finally that given the district's articulated positions on this one critical issue that has 2 components, I would anticipate that the permitting, if we don't get guidance from the hearing board here, we're going to have problems in the permitting process, and we may end up back here. But I think the hearing board's guidance on this issue, if we do come to a conclusion that allows Baker to operate, which we're confident would protect the community from odors, then that would provide a lot of guidance for the parties moving forward on permit conditions.
When I look at the order, the requirement for the PTE, I'm only seeing it on the the trash area, basically the centrifugal operation. Maybe I'm missing where it says on the extension of the receiving area. Let me see if I can find that.
I'm sorry, I'm looking for the language myself.
Yes, enclosures, let's see. Well, yeah, so number 11, where it says not used as a collection center unless it is, permit to construct for the 3 enclosures that 8A have been submitted, which 8A then refers to attachment. It's not there. Let's see. 8A. I have to go to another document. Oh. So 8A is in attachment A is specifically the grease pit, the skimmer trash bin, and the centrist trash bin, which are identified exhibit A. It does not talk about the receiving area. And I, assuming that permit is still pending for the receiving area, correct?
Correct. We are waiting the issuance of that draft permit.
Right. So why is there no reference to the receiving area expansion? Or is it there somewhere that I missed it?
So I believe there is language that the parties have added to the hearing board's proposed order in 8A or in section 8, which says that the district requests additional information to process the applications for enclosures and the raw material area expansion. Baker shall provide such additional information within 5 days, within the time frame requested by the district, whichever is later. I believe the order certainly contemplates Baker constructing the raw material extension, and unless, I think we all agree that unless or until the raw material receiving area extension is constructed, the volume that Baker can use, oh, here it is, but the volume that Baker can use is limited. So if you look at the attachment A, section 2, it says if Baker's permit application related to its raw materials receiving area enclosure expansion is withdrawn, denied, or rejected, Baker shall submit a new permit application to operate as a collection center within 7 days from the date of withdrawal, denial, or rejection. The effect of that is to say that Baker has a pending application for a permit for the raw material area extension, and that if that extension is withdrawn or rejected or denied, they need to we need to submit a new application to operate as a collection center. So that would mean either renew or revise the application for the raw material extension, or somehow come to some other agreement with the district regarding how the collection center could operate.
So just to, thank you for that. Just to clarify in my mind, so that you need this order, you're saying, because you want to bring in raw material up to 60,000 pounds initially, because I think the order says you're not going to do the pit area until you get the permit for the enclosure of the pit, correct?
That's not correct. The order says that we need a permit to modify the pit, which would be to pull the screws and put in the panels, or obviously we could have the permit for the screw conveyor, which is in conjunction with the raw material receiving area extension. So Baker can use the pit under the way this order is drafted. Baker can use the pit and store up to 175,000 pounds if we get the permit to modify the pit, pull the screws, and put in the panels, which would be an interim measure prior to the granting of a permit for the screw conveyor system and the PTE extension that was described at earlier hearings.
I thought I saw somewhere saying it will not be done until the permit is issued, because there's so many versions of this.
No, sir. If you look at 11B.
11B, okay.
Yes.
Prior to the, okay.
The revisions that I believe the parties have agreed on say prior to the modification of the pit, removal of roller and placement of panels, or installation of the permitted screw conveyor system, Baker shall store a maximum of 60,000 pounds of hard material on the slab within the raw material enclosure at any time. After modification of the pit, Baker may store a maximum of 175,000 pounds.
So my question for clarification is, are you waiting for the permit for the modification before you do that, or are you going to go ahead and, once you do the modification to the pit, then you'll start increasing from 60,000 to 175?
So it depends on what modification you're talking about. If we're talking about the panels, pulling the screws and putting in the panels,
Right.
there needs to be a construction permit granted for that from the district. Once that construction permit is granted, those screws will be pulled and the panels welded in with the drainage system that, again, we can describe in place. And that will allow Baker to operate at 175,000 pounds.
Okay,
If-
I think that answers my question, which is you want to do 60,000 initially until you get the permit for the modification. Then you will, once that is approved, you do the work and then do increase to 175,000. So the order of
Correct.
abatement. Okay, I got it now. Thank you. I appreciate that. I have no further questions. Yeah.
Any additional comments from members of the board? All right. Mr. Jagin.
I just want, sorry, I
Go
just
right
wanted
ahead.
to make just one comment. I really appreciate the fact that you did come back with a schematic because it makes it, I think, a lot more real to us to be able to look at that. And at the time that I'm assuming one of your colleagues is going to go through it. But I just wanted to thank you for doing that because for me, it makes it a lot easier visually.
Our pleasure, and thank you for
So-
pointing out the need for that.
Balaka Palan.
Yeah. Since you already have, and I don't think you're disputing the condition to operate between 6 a.m. to 9 p.m., correct? And you also, and 60,000 pounds. So there's already operational constraints and in place, hours and amount. So what I'm hearing is you're asking for operational flexibility for moving the material.
Correct. Yes,
Okay.
sir.
All right, thank you.
All right. So you want to continue with your closing?
Yeah, I will be quick. I think the last issue is the odor response timing. And here, the concern is just that when there's nobody at the facility, the time it would take to complete the steps of the odor response plan could be longer because it could take some time to get somebody to the facility. But there's something else I think we want to keep in mind here. When there's nobody at the facility on that day that it's closed, there will be no raw material at the facility. So remember that when under Baker's proposal, all raw material will leave the facility and the pit will be washed down before the facility is vacant on that Sunday. So in essence, it would be, I mean, I guess there could be a situation where some crazy thing happened and there was some pile of raw material somewhere, but I think that would be very unlikely. And so the issue, we're not really arguing about something that we see as particularly consequential. And so what we could do is the hearing board could insert the provision that if Baker can substantiate that there is no raw material at the facility during those closed days, then Baker would not need to go through those odor response steps, which all have to do with ensuring that there's no raw material leakage or that there's no, open doors or open panels and so forth. And so, perhaps the hearing board could write in some language, and perhaps even district council might agree that if Baker can demonstrate or substantiate that there's no raw material at the facility through an attestation or some other method, that the 8 hours would be sufficient, or that there would not need to be that response. Because remember, this is an area where there's a large rendering facility. There are other odorous operations completely unrelated to Baker from other companies in this immediate vicinity. And so odors detected at the property line might, if there's no raw material at Baker's facility, would more likely be related to something else.
Mr. Bellicapelli retains the floor.
Mr. Jimenez, I think I brought this issue up last time about, it's on page 59 of the staff report for Rule 415. And it did say in Texas, they were using a positive deodorant food grade odor suppressant. So if I were to propose a condition, and I'll check with the district, that you will investigate that what Texas is doing and implement it if it's found effective as soon as, within a certain time, as a way to, until we get until we have a handle on what exactly is the order in this situation, that there is some other effort being taken to suppress the odor. It appears from the staff report that was effective in Texas. Is that something that, if I were to propose a condition as to investigate and determine if it's feasible and then implement it within a certain time frame to suppress the odors?
If it's something that's necessary that the hearing board feels is necessary in order to allow the timing provisions that Baker has proposed here, then I think our answer is and has to be yes. I mean, Baker is willing to investigate whatever methods the hearing board believes might be effective that are obviously within reason and feasible, and so yes, the answer would be yes.
Yeah, and I'll check with the agency also, because that way it address the operational flexibility and the time, because so that's okay. I will do it.
Any additional comments or questions from members of the board?
Yeah,
Mr. Bellicapelli?
well, I do want to hear from the district on that proposed condition by the appropriate time.
Absolutely. Mr. Jagones, are you finished, or did you want to conclude?
I know that Ms. Neal is ready to walk through the drainage schematics of the pit if the hearing board would like. Hopefully they're easy to follow on the 3D renderings and the blueprint renderings, but we are happy to do that. And otherwise, I would just reiterate my thanks for the very careful attention that the hearing board has paid. I'd also give thanks to district council for our ability to work collaboratively with them to get to this point. My hope is that this is the beginning of Baker's ability to conduct this operation and not the end.
All right, Ms. Neal.
Thank you very much. I'll begin by sharing my screen so that members of the public who may be joining can see what I'm looking at here. I'm looking first at this first page of what has been titled Exhibit KK. This is the larger schematic on that large piece of paper. This schematic demonstrates that Baker is able to use what they already have within the pit and some of the infrastructure that's already in there, and update that and add to it in order to create a functioning drainage system. You can see here that there are both purple and green lines. Those lines are pipes that will be put into the PTE.
Chair, if
Ma'am?
I believe it would be more appropriate for a witness to provide testimony versus an attorney. If you wanted to hear testimony regarding these exhibits, perhaps it'll be appropriate for Mr. Andreoli to testify.
Well, I guess I'm just curious. She's walking through the exhibits as exactly what you did. It's a similar exercise.
Mr. Chair, I do agree. I think we do need a bit, it's a technical drawing. I'm not sure saying the attorney cannot do that, but I think she's testifying to some extent what it is they are constructing or proposing to construct.
Mr. Pimmel, what say you?
I think we should have the witness discuss it.
Okay.
As opposed to the attorney, yes.
Not a problem.
Certainly.
So just for the record, going to state your name, and then you're going to walk through KK. Each of the various documents is contained within that exhibit.
Jason Andrioli.
And just for the record, he took the oath weeks past, so
I have.
you're in good stead. Go right ahead, sir.
Good morning, everyone. So to go into the description, it's without a laser pointer, it's a little bit difficult, but I will use the numerical system at the top to try to describe where it comes from. On line 3 and 6, at the edges of the raw material pit, water will drain into the 2 corresponding boxes right below where you see where the trash pump states. Water will fill up in there, and the trash pumps will then pull water from these boxes, which we call vaults, and then it will transfer through a clothesline over to in between lines 1 and 2, which is a sump. And from that sump is then pumped out through a closed system to the wastewater treatment plant.
And then if you wouldn't mind going through just a couple of these other renderings that we have here, and I'll pull them up on the screen at the same time.
Okay.
Before you do may I ask a question regarding the schematic?
Absolutely.
Okay, all right, so I'm following what you're saying. Where exactly is the drain and how many drains are there?
Where exactly is the drain? So if you see in the raw material pit, all those arrows that are going opposite directions, the drains are going to be, it's kind of hard to describe, at the very edges of the raw material pit where those corresponding arrows are going. And then it'll go into the box that sits right below the trash pump, and it'll fall in, the water will fall into there.
So there's 2 drains?
Yes, there's drains on either side.
So just to make this a little bit cleaner, why don't you, can he utilize your laptop and use a little hand there?
Yeah, sure.
And the hand can kind of guide.
Oh, that, I appreciate
Yeah.
that. So here this is where the screws or the plate would be right here. And the water would drain down this way. And here is the edge of the raw material pit. And there would be latches and air holes where water would then flow into what we call here is the vault. And the same thing will happen on this side as well. And from other pictures that we were gonna pull up here, which show a little bit more detail, you will have a trash pump sitting on the upside of this, which pumps water from the vault up over on both sides to a sump. And from that sump is like a closed box in the ground. And then that pumps through a closed system to the wastewater treatment plant.
Okay, so it goes to the wastewater treatment plant, okay.
Yes.
Thank you.
You're welcome.
Any additional questions while we're on this particular artifact? Okay, go right ahead, Mr. Andrioli.
I am going to start going through some renderings. Oh, looks like I have to.
Just a suggestion, maybe you'd want to call it rendering.
Some images, how
last
about
time.
that?
How's that?
Okay, we can start with this one. And just go ahead and explain for the board what we're seeing here.
Yeah, so in the prior drawing, I was talking about how water is going to drain down from either side of the raw material pit, and it's going to drain into a box. So this is the box, and this, the drainage area is underground here. And as you can see, there is a pipe that's going into, I guess, the vault or the box, which is going to pump up and then down over into the sump pit. And we haven't quite decided if like this line will be underground or if it's going to be above ground yet. But that's the only general change we would make.
Unless the board has any questions about this image, we can move on to the next one.
Yes, are there any questions? All right, let's move on to the next document before us.
Thank you. what we're looking at now is the next page of Exhibit KK.
Yeah, this is, an additional drawing, kind of just giving a little bit more overview of the raw material pit. As you can see, the drainage goes down in the slots here into the box or pit where the water is going to discharge into before being pumped over. Keep it simple.
Right, we can pull up the next image and board members, please, I'll try to go through these quickly, but please feel free to stop me if you have questions on any specific images.
That's just another drawing. This one's with the plates in place for the raw material to show how the water would drain down into towards the vault or drainage box before being pumped over.
Are those holes there for that material water drain down or in the plate?
Oh, no,
No.
yeah, I think that's just a engineering.
Oh, okay. Rendition.
Yeah.
Next up.
So as you can see here, this is, as I was talking about earlier, there was a pump right here with the line that goes down into the, what we call the vault, and here are the drainage points. Right here where the water would discharge into and the water would come up. And this is another viewpoint from, as you're seeing, the vault was on this side where you saw that big box, the underground one. And this is showing how the layout of where the water is going to drain down into those holes into the vault. And this is a general side view of, giving a better viewpoint of the sump where the water is pumped over from the vaults, from the raw material pit. As you can see, this is the vault here. Here is the line for that pumps up the water to the sump. I'm sorry, to the pump, which it transfers over to the sump and then pumped over to the wastewater treatment plant.
Maybe just one more image to show.
And once again, this is another viewpoint. This is kind of corresponds to everything that's kind of what's going to be going on. Once again, it's a raw material pit, dumping into through these slots and drainage into the vault. The water will then be pumped up through the pumping system to the sump pump and out to the wastewater treatment plant.
Just follow up.
Right here, Mr. Pollack.
Mr. Enroli, just if you can just bring the back of the last image, just for clarification, the pumping, the sump, and the trash pumps and so forth will still remain in place even after you remove the plates when the extension is approved.
That's my understanding.
Okay, so only thing is the plates will be removed, so then the screws will be put back once the extension is approved.
So the plates would be removed, the screws would go back, and then the loading screw would be installed.
Okay, and these pumps will be permanent for
Yes.
plate for. Okay, all right, thank you.
Counselor.
There are no other questions from the board. We'll conclude our presentation of the pit drainage schematics. Thank you very much.
All right, Mr. Balakapalan had a question from your side of he wanted you to discuss. Yes, she's already concluded.
Yes, I'm finished.
Oh, yeah,
Unless there are any
no.
more questions.
Right, so go right ahead.
And the district has no questions for Mr. Andreoli.
Oh, Ms. Sue, one of the proposed condition is, is that reference to Texas, what they did in the staff report. I'm pulling it from the staff report, page 59 of the staff report, where they did some food grade possibly deodorant and this is for the material that is brought in. If that is imposed as a condition, if it's feasible, I mean, we'll have to have them investigate what Texas did and what type of food grade, and and if that is feasible and practical. And I was going to propose that as a condition that they investigate and implement it. Would that be enough to give them operational flexibility in the district's as far continue? I mean, for this temporary operation until they finish the total enclosure, the extension of the total enclosure.
I think I would have to understand more how the deodorant works and how soon it could be implemented. I do know the odor response plan that Baker has, it does mention turning on misters, but I would need clarity on what the misters do.
Yeah, so my proposal would be for them to investigate and implement it. Let's say investigate, I'll come up with the dates within a week or so of the order been issued, and then implement it if it's deemed practical and effective based on discussion with the folks. And I'm not sure which facility in Texas it is. So, the staff report, I maybe have to go through it, but I'm just going by what is said. And it appeared that it was staff had done some investigation during the part of the background for the rule. And so that would be a control measure. Because at this point, like Mr. Gigona said, we don't know if there's really going to be an odor problem. We expect there will be because of all the meat and so forth there, but that will because the order, the abatement order, there's nothing to abate until they, it's like it's a preemptive abatement order, but assuming there's a potential for odor, it's not until there is is effective when there's the order abatement after the fact, but we are doing it before. But I think there are two parts of it because they're constructing also the equipment while and want to process the material so that the order abatement will address that, allowing them to bring the material while they're constructing it. So I think the extending the order makes sense. But the second portion of it, they are not operating yet, and we not 100%. We don't know what the orders will be. So in the interim is what I'm proposing, that they investigate and apply that material. I don't know what the demisting is doing, like you said. So they may have it might be water. Who knows what they're doing. But in addition to that,
We would be in favor of more odor controls. Yes.
Okay. All right. Thank you. But I'm sorry. So by imposing that condition, I was willing to look at giving them operational flexibility in on how many days they can keep the material, basically.
At this point in time, without knowing what the deodorant does, and also I don't have authority to agree to additional flexibility regarding the days.
Okay, thank you.
All right, members of the board, are we ready to deliberate?
I just have a question based on
Ms. Sue? Yes.
based on Ms. Sue's comment that you don't have the authority to change something. I mean, isn't that what we're here to do, is to try to negotiate back and forth, whatever it is? And if you don't have the authority, where's the person who does?
If you need me to seek additional authority, we would need to take a break and I would need to talk to someone else. Right now, as I sit here, I haven't been given additional authority on certain matters to agree to changes. So I would need to go and take a break and talk to someone.
Okay, thank
So
you.
Ms. Sue, how much time would you need in order to confer with your superiors, because I would like Mr. Balakapalan's point to be discussed so that once we come back, we can move forward and we can render a decision today. So how much time do you think you need?
Perhaps 15 minutes, and if I could get more details regarding Mr. Balakopan's proposal in terms of how many days, that would be helpful.
I would say they investigate and make a determination within 7 days of the issuance of the working days of this order, and implement the order control measure within 30 days. If it's determined to be practical and feasible.
I meant in terms of flexibility, in terms of removal of the material. You're saying you would want them to use a deodorant system and allow them additional time to remove the material. So how much additional time were you considering?
I was not considering any restriction actually, because there are two restrictions already in place: the amount of material they can bring daily, and there's also a restriction on the hours of operation. So there's already operational constraints there, in that regard. And so the concern that you've raised rightfully is maybe the potential for odor from the material sitting there for a longer period of time. And my proposal is that then they add, this odor control measure to reduce any potential. So that I think I heard, at least for me, I heard you need some, for a business to run, you need that operational flexibility. There's nothing in the rule that requires this type of, requirement per se, because there's no rule for this operation. So I do believe the hours of operation and the throughput is already a constraining factor.
So based on Baker's proposal, it would be basically removal of the material every 3 days and using the deodorant system.
Yes.
Okay. So I can take that back to my superiors, or I don't know if you have any further questions you may want me to ask my superiors.
Yes, that's actually a good question. Are there any additional questions we'd like to proffer, Ms. Verdugo?
Yes, I was going to suggest in reference to the emergency situation where AQMD is proposing 3 days and the Baker facility, they want 9 days. Why can't we just negotiate and do 6 days? That's what I was going to propose, because it's in the middle. It's, trying to give them the ability, because I know that they're going to have emergency situations in reference to the materials that are coming in. I don't think 3 days is enough, realistically. And based on how they have described the business. So I would be proposing 6 days, if that is agreeable with Baker.
Madam Member, through the magic of text, I can confirm that we can do 6 days if that's what the hearing board would like.
Okay, so that we can have a stipulated agreement. You can take back Ms. Verdugo Peralta's concerns, Mr. Balakapalan's concerns. Any additional concerns that members of the board would like to proffer?
That we break for lunch.
Well, no, true. So we're going to actually wrap it all into one. We're going to give you what you need. We'll come back around, I say 12:25, 12:15, 12:20. Okay, so we'll come back at 12.
30 minutes or 45 minutes?
Well, she needs 15 minutes to confer, and then
And she needs to have lunch too.
okay, so let's just make it 12:30 because we have to adhere to provisions of the union contract. So 12:30. We're off the record at 11:32 a.m. All right, is everybody ready? Okay, we're back on the record at 12:34 p.m. Okay, Ms. Sue, the floor is yours.
Hi, good afternoon. I did get a chance to confer with my client regarding Mr. Balakopolan's proposal. We do agree that it is a good idea to investigate the use of deodorant, but we don't have sufficient information at this stage to determine whether or not it'll be effective enough to prevent potential odor issues, and we would not agree to allow for additional days of the material being there overnight until we have sufficient information. As to Ms. Verdugo Peralta's suggestion regarding 6 days of emergencies, given the community's concerns, we do believe 3 days of emergency is what we should recommend, and we are sticking to that recommendation. Thank you.
All right, members of the board. Down to deliberation, Mr. Pearman.
So I have a couple of ideas on the language and at least to start the ball rolling. First, the district had asked about the language in 8 and 8 and about what happens if the parties can't reach agreement. And I believe we should just leave it with the status quo. Again, if they need more time, either they come to us for that or they come to us to suspend. We're not afraid of having hearings in important matters, so I'm not going to change that as my recommendation. And then on some of the other substantive items, again, the issue here is really odor. We're not talking about noisy trucks or lights at night, things like that. And so I think that concentration on the odor issue kind of informs how I see we should react to some of the provisions herein. And so on 11C, I agree with the language of the district, except as Cynthia said, there's no real magic or science behind the numbers here. So I would go to 6 days of emergency use operations in every 90 days, not just 3. I'd go with the 6 days in that 11C. And then in 11E, I would make a couple of changes. I think that I would take the language of Baker, but use 2 days of its arrival, not 3, not overnight, but 2 days of its arrival. So give them less time than they requested. But then I would give back a little bit of a compromise and give them the exception if there's emergencies. So I would take their 11E and add at the end of it, as stated by the district's earlier proposal in 11C, except in the event of an emergency, in which case the material must be removed the following day by midnight, ... Only 6 days of emergency to be consistent with the change we just described. So it cut again, break it down to 2 days, but give them this emergency out as like a counterbalance, if you would. And then my next comment will be on, let's see here, it is also in 11F, which is Baker's 11F. And it's a provision that's slightly new compared to the districts. And I would agree to the request of Baker in their proposed 11F. So what I would do drafting wise, rather than change section numbers, I would add Baker's 11F to the beginning of the district's 11F. So the phrase before the screw conveyor, et cetera, would go before Baker shall inspect the exterior of the raw material enclosure. My next comment would be on the 12A Roman numeral 5. And I would go with Baker's language, which includes, in distinction to the district, a couple of exceptions about not requiring them to wash the interior of the facility's raw material enclosure screw conveyor and only be required to wash the pits twice per week in compliance with, again, the 11AF that I just suggested we take from Baker's. And then lastly, under 12A, Roman numeral 7. Again, I would split the baby, so to speak, and in case the facility was closed and no staff available, the district had proposed 8 hours of Baker to complete the required steps. Baker had said 4. I would make that 6 hours in 12A, Roman numeral 7. So those are the changes I would propose, along with whatever Mr. Bullock-Upon or others may suggest.
Mr. Balakapalan.
Yeah, sorry, let me just, I brought up the staff report. I want to just read that paragraph. It says the raw materials with the potential to produce nuisance odor condition, and all raw materials that have exceeded 24 hours of on-site storage shall be treated with ... They didn't want to put the brand name, with positive deodorant, food grade. I just lost it. Food grade odor suppressant. So, so I would propose a language that they investigate 4 situations where they've exceeded 24 hours on-site storage, that they treat it with this positive deodorant, food grade suppressant, but with that they do investigate within 7 days, provide the feedback to the district. And I come up with a specific language, but I just want to give you a general, and inform the district of what they found. And then if it's found to be practical and feasible, that they implement this within 30 days. To, and that, but that would, I'm not sure if it's going to conflict with, so I'm sort of removing the restriction that everything should be moved daily by midnight. Did you you didn't have anything on that, right?
Oh, I think I just said they had to remove within 2 days. With
2 days. Yeah. Okay.
Any additional comments from members of the board?
Yes.
Ms. Verdugo-Peralta, the floor is yours.
I'm looking at, I guess it's 11 Roman numeral 6 regarding cleaning the floor drains. Accessible interior and exterior floor drains shall be inspected and cleaned not less frequently than once per month to remove accumulation of rendering materials. I don't think once per month, though, is enough based on the fact that we increased the throughput. I would be much more comfortable at minimum with twice per month, since we did increase that throughput. You guys agree with me on that?
That's 12A, Roman numeral 6.
6.
To make it twice per month.
Right. Is that something that Baker can agree to?
I believe so. And I would say we should say accumulation of raw materials, just to keep the language consistent.
Okay. I'm good with that.
Are there any additional augmentations or slash amendments? Mr. Pearman, floor is yours, sir.
Well, just to be clear, Mr. Bullock-Upon's amendment would, I guess, get rid of any requirement to remove things daily or 2 days or 3 days. Is what you're suggesting, that it's just, it has to be treated in this fashion if it's feasible?
Right. But if they're accepting the 2 days, which you suggested, then as I keep the 2 days, but they also should investigate, this product and see if it's feasible to, and we can revisit it after that, if it's deemed effective.
Yeah, I would say, if you don't mind, let's keep what I suggested,
Yeah.
but then have them investigate that.
Yeah, no,
Turns out it works, presumably even they or the district will run and say,
Sure.
we should.
Yeah, no, I agree completely, because they agreed the 2 days. I think the daily removal is what seems to be the hang up.
Mr. Balakapalan, would you be interested in the hearing board maintaining a measure of jurisdiction over a defined period of time, or?
Well, I think there's language in the end that says we will be, until a date we determine, they'll come back, So this order doesn't sunset right with this issuance of the order today. I think there's language, I forget what number that is, that they have to come back to.
Yes, it's number 16.
Yeah. So yeah, we have to fill in that date, yeah.
Okay, any additional amendments?
Does that address, do you know, everything that was where they were where they were not stipulation? I wasn't able, this is a little confusing going back and forth. I didn't get all that, but
Yeah, see, well, Mr. Perriman, go right
Well,
ahead. sir.
I feel it did. My version was I was working with the district's version, except where I spoke differently, but we can ask them one more time if we missed something, but I think we took care of what they
So
disagreed upon.
the concern is perhaps in the motion, you'd bifurcate some items that would be stipulated, others would be non-stipulated.
or we can just make those changes but we have to pick which order.
So, Mr. Perriman,
Dr. Abraham,
you're working off of 45, is that what
Yeah,
you're
that-
working off of?
or 40.
Well, actually, 43 is the.
43?
Clean
Okay,
version, yeah, so-
43. Okay, so I feel like maybe can we review then all of the changes on 43 and then say that's what we're gonna vote on? Just so we make sure we all have the same.
so one thing is for sure. The district is not going to stipulate
Well,
at least 3 to 4 items. So if we make it clear, we can go over as Dr. Abraham has suggested or requested, but just know that we probably want to have within the motion an opportunity to know that, so that it's very clear.
Yeah,
But
and we don't always, it's not necessary to have stipulation on both parties for us to, we can always, the board, if the majority votes to amend it, then regardless of what the party's position is, I think we've done that in the past, and, if we think is reasonable and majority agrees, then.
Fair enough. So Mr. Pittman, would you like to just simply walk us through the compilation?
All right, well, so at least for the ones that I had.
Mic up, Mr. Pittman.
So 11C, again, working off the districts.
That's number 43.
Number 43.
okay,
We just changed that from 3 days to 6 days, the second line of 11C. And then 11E. 11E, we would first take the language from Baker's 11E, which begins with the words, "No storage of hard material shall remain overnight," ... And
I'm sorry, Mr. Pima, is that the clean version or whatever?
yeah, the Baker.
Baker's clean,
version,
okay.
yeah,
I then, that's
which is
I,
Aye,
yes.
okay.
and you're reading
11E. Their 11E, except we would change it to in 2 days of its arrival, comma, at the latest. And then comma. And then we go back to the district's 11E, the second line, except in the event of an emergency, et cetera, et cetera, et cetera. Only 6 days of emergency every 90 days shall be allowed, et cetera, et cetera. So again, 11E, we take the districts, the Bakers, change 3 days to 2 days, but add the exception from the districts 11E with the change to 6 days of emergency, not 3 days.
where was the 3 days? It's in E?
In 11E, about the fourth line of the districts,
Oh, the districts, okay. I see. Okay, so Baker's, I did not have that specific language, so now we're taking from the districts. Only 3 days of emergency every now.
changing it to 6,
Uh-huh.
the exception. Mhm. And then we would add to the beginning of 11F of the district, the entirety of Baker's proposed 11F, which begins before the screw conveyor in the facility's raw material enclosure is permitted. That would go now in the district's 11F in the first part of that, to start that paragraph 11F. So the entirety of the Baker proposed 11F will begin 11F as proposed by the district.
And removing the Baker's 11F, you say?
You're moving it to the districts, the whole.
The whole thing entirely to the, okay, yeah, to that, okay.
And then we have again, 12A, Roman numeral 5. We'll go with essentially all of Baker's language would be 12A Roman numeral 5. And what's relevant there is the exceptions, the two exceptions that Baker included that will go into A Roman numeral 5. So all of Baker's 12A Roman numeral 5 would place the district's proposal. And then in sub 6, per Cynthia's recommendation, you'll refer to not less frequently than twice per month to remove accumulation of raw rendering materials. And then in 12A Roman numeral 7, about the 6th line of the district proposal, Baker shall complete such steps within 4 hours. We'll change that to 6 hours, to 6 hours. And then we'll have two other things would be the Mr. Bologapon's language and a suggested date for a later hearing in 16 have to be completed.
So I would add then my proposed language to 12 under order best management practices. So it'll be 12 Roman at 10, not a petitioner, the Baker shall investigate the use of positive deodorant food grade odor suppressant for controlling odors on the raw material received that are over 24, on the raw material received, if they're there for more than 24 hours a day. The reference, and I'm not sure, how to put this, because refer to, I can maybe say refer to the staff report page so they can look where that's coming from.
Yes.
It may be in parentheses, refer to AQMD staff report for rule for page 59 of proposed rule 415 on the use of positive deodorant food grade.
Madam Clerk, are you capturing?
Do we need to?
It is recorded, and I generally would clarify with the board members to provide you with
Specific language, okay, and I will, but they will investigate and I didn't add and report, they've investigated within a week of the granting of this order and then report to the agency, with the findings of the use of this food grade additive, and I'll fine tune the language if that's, agreeable. So that'll be the 10th under order management practices.
Okay, so when would we want the entity to come back?
No, yeah.
Well, before we do that, can we, maybe I didn't catch it. Did we change 12 Roman numeral 7 to from 2 to 6 hours? Did we cover that?
Yes.
Yes, we
Okay.
did. That was amended.
8 to 4 is what we did. Or 8 to.
I'm looking,
7?
I'm looking at 7.
Yeah, we did, he said 6 hours.
Right.
Yeah, we split it to 6 hours.
Okay. Just wanted to make sure.
All right, so what is sufficient time to return?
This is what, July, so.
Is October too far out?
Didn't you say something like, wasn't there seven?
Maybe how long is it going to take them to incorporate all of this? Not to mention the permit time. So I guess the question would be to Ms. Sue.
So what, can I ask again? So,
Well, hold on one second, Dr. Abraham. Ms. Sue, you want to answer Ms. Verdugo-Peralta's question?
My understanding is that the facility would need at least a month to get the loading equipment. So we would need at least maybe 2 months from now to kind of see how their operations is going. So I recommend at least more than after 45 days, maybe around 60 days.
Okay. Dr. Abraham.
Sounds good.
that's not 60 days for what Mohan's proposing, right?
No,
Because
no,
you're
no.
asking to do what? Study and report back.
Yeah, within,
And what is that, what is the scope of this evaluation? That it mitigated entirely, or that, like,
so,
how do we know that it is effective? Are we?
well, you
saying
have to, again, there's not much in the staff report, but you have to depend on what the Texas facility did. So somebody has to contact them, find out if it was fiddle, maybe they stopped it. I don't know. I'm just, and so they want to investigate and see if that was effective. They're still continuing it. What kind of food grade additive is this that they're adding, and how effective it is to controlling the odor, and then and report that within a week to the district.
So I'm proposing October 24th. It's a Thursday,
that takes that long to do?
Yeah,
this?
that's fine, but
October 24th.
I also think we should check and see if there's anything areas of where we've missed, where the difference of opinion.
Well, we're kind of in deliberation, so I think that we're good with respect to that. October 24th is the date, and they'll come back.
May I,
That's a Thursday. And because we're so far out, if there is an issue or concern, perhaps they would get in contact with the district. The district would then work in concert with the clerk's office, and we would go from there.
Mr. Chair, may I ask one question?
I forgot you were there. Go right ahead, sir.
Thank you. It just the concern on our end we're very happy to investigate the odor suppressant and very happy to report to the district on the results of that. The concern is just that 1 week would include, right now, 1 week would include the 4th holiday. And so we have some concerns about being able to get in touch with people and get information back. Would we be able to extend that by a week or 10 days or something like that?
Yeah, I mean, that was arbitrary. Yeah, within 14 days. How's that?
The gentleman stated within 14 days, Counselor.
Yes, sir. I think that would be good.
We'll note that accordingly. Okay. All right. Motion, is there a motion laid up on the table?
Sure, I'll make a motion that in this matter, case number 6223-1, request for modified order for abatement, second modified order for abatement, AQMD petitioner, Baker Commodities, facility ID number 80016 as the respondent, facility at 4020 Bandini Boulevard, Vernon, California. That we enter the order as set forth in Exhibit 43 with the modifications that have been verbalized of my proposed changes, and Mr. Volkan's change, and Ms. Verdugo-Peralta's change. The exact language of Mr. Volkan's change to 12A Roman numeral 10 will be clarified to the clerk. And of course, this includes setting the next status conference for October 24, 2024.
What's that? Was that it for everything? Yeah, I second.
All right, let the record reflect that the item has been moved by Mr. Pearman and second by Ms. Verdugo Peralta. Any further question or discussion on the motion? Hearing none, roll call. Mr. Bellica-Palan,
Aye.
Mr. Pearman,
Aye.
Dr. Abraham,
Aye.
Ms. Verdugo Peralta,
Aye.
and Ali vote aye. The record is clear. The item is passed. It is approximately 1 p.m. There's a matter on the agenda that states closed session. Let the record reflect that we do not have any matters for closed session. Let the record also reflect that no one has provided public comment pursuant to California Government Code 54954.3. Any members of the board desires to providing any comments at this point? Parting comments? Let the record reflect that there's none. We're adjourned at 1 p.m.
Thank you, board members.
and off the record.